down the hammer and pick up the pencil. You're about to listen to the Savvy Radio Show. Learn from real-life real estate investors, experience revealed with the Savvy Landlord as your host.
So my name is Ryan Schaller. I'm an attorney here in Oklahoma City. I office in Edmond currently. I can send this out by email to Steve, and you guys can all get copies of it. This is my bio, which I don't show to try and say I'm important or anything, but I think it's interesting to know where people are coming from. I graduated law school in 2011, kind of in the height of the recession. And so what I started doing when I got out of law school was taking images for oil and gas companies while I was waiting to get my bar results. So I started out as a landman, which was my introduction to title. After I passed the bar, there was a firm in Enid, Azell and Shepherd, that did work for banks in the northwest part of the state, rural banks that lend to farmers and cattle ranchers and stuff. And they had me start doing title work for banks. So my introduction was through oil and gas landman activity. Then in Enid, I did a lot of title work for banks. In 2013, I moved back to Oklahoma City, where I became underwriting counsel for First American Title and Trust Company, and stayed there for several years, eventually becoming senior underwriting counsel. And I signed off on all the title opinions for Oklahoma County for about 4 years, and Pottawatomie County, and a lot of Canadian and Cleveland. So if you had problems at First American in the last 4 or 5 years, you can probably blame me. Sorry about that. Some other things about just kind of what my background are. I'm very involved in the Bar Association and their real property section. I think it's important to stay very in touch with new legislative developments and new ideas. I'm also, the very bottom one there, I'm in the Oklahoma Land Title Association as well. That's what all of your abstractors and title insurers are part of. So I do a lot of work with them as well. So my goals for today were essentially, my background, I do a lot of title work, and I get a lot of title curatives. So I get a lot of calls from people who've acquired properties. Maybe they've been assigned the contract and deed, and they're trying to figure out how they can get this property closed because they've got a closing lined up. Title company comes back and says, you've got to take care of this contract for deed. You got to take care of this. So in my situation, I get a lot of questions about how do you handle contract for deeds? What are the differences between them and other options? What are lease purchases, and how do those affect both your title, your risk, and what are the differences? So I want to start off by just kind of going over what the differences between these three different types of financing options are and what they mean for you as a seller. I also want to put out a little disclaimer. I don't do tax law, so I'm not here to give you tax advice. If you have questions about income tax, I am not the best person to answer those. Okay, so first I want to talk about mortgages and notes. These are the most traditional financing method, and it's probably the one you guys might use the least, I'm thinking. So with a traditional mortgage and note, what you're doing is you own the property, you sell the property to a buyer, the buyer executes a mortgage in favor of you covering the property. You have a promissory note, which is not of record. It's something that you just keep for your own records. A lot of times the mortgage may not have all of the terms on it. It might not say when the maturity date is. It might not say what the interest is. It's possible to not even include the amount on the recorded mortgage. All of that information is found in the promissory note if it's not on the mortgage. So if you're doing the traditional mortgage route, you have a little bit more upfront expense. The reasons for that are you're creating two documents, the mortgage and the promissory note. You have to have a promissory note because you can't foreclose in Oklahoma unless you have it. So that's one of the issues with mortgages. Your other cost with a regular mortgage is you're going to be paying mortgage tax when you record it. That can add up if you're talking about a high enough expense. Another disadvantage with a regular mortgage is you are going to have to prosecute a foreclosure against your buyer if they default, which, if you've done that before, it is around $4,000 to $6,000 depending on how much they fight it. So that's definitely a disadvantage to using the mortgage. Some of the advantages, though, and some of the reasons that people like these on bigger deals, is that the level of detail when it comes to your remedies and how disputes are figured out in a mortgage is just so detailed compared to any other option. You have a lot of certainty. So again, that's kind of the mortgage option. The promissory note is a second document that you keep yourself. Foreclosures aren't cheap compared to other court actions you all might be familiar with, like probates, quiet titles. If I'm doing, I finished a quiet title on Monday against an oil and gas pipeline. I went to the courthouse twice, the day I filed it and the day I took my order to the judge. I do a foreclosure, I'm going to be in the courthouse 7 or 8 times. That's why they get so much more expensive. So that's sort of the reason. I get to ask this bottom question a lot. People want to know if they've acquired a property that's subject to a contract for deed and they've got to take it to a foreclosure. What happens if someone else comes into that sheriff's sale and outbids them? Do you lose that money you put in? So the judgment at the end of the foreclosure, before you get to the sheriff's sale proceedings, will set out the total amount of money that is owed to each creditor. So if you're the holder of the contract for deed, if you're the holder of a mortgage, you'll have something in there that says, I like to use round figures. Let's say this is a $100,000 property. The contract for deed value is $80,000. That's how much is left owed on it. So you go to the court, you get a judgment for $85,000. The $80,000 plus your attorney's fees and costs. It goes to property sale for the sheriff. Someone comes in and bids $105,000. You don't want to pay $106,000. You're already into this. So they get the property. Your judgment, that $85,000 gets paid to you out of the court. Then whoever else might have a judgment against that is going to get paid the excess on those funds, or the court's going to keep part of it. But that's the mechanics of how that works out. I get asked that on calls quite a bit. Power of sale foreclosure. If you are going to do a mortgage, and we'll talk about this again when we get to contract for deeds, which is the next section, Oklahoma law allows you to use what's called a power of sale foreclosure, but you have to plan to do it from the very beginning. It actually states in the statute that this phrase must be included on the document of the mortgage, and it must be bold and underlined. If you've ever seen those mortgages that have the big bold underlined section at the top, it's because they're power of sale foreclosures. Power of sale foreclosure can be done a lot quicker than a regular foreclosure and a lot cheaper. If there are other liens on the property, there might be problems with that. They are not as good for when you need to foreclose out other lien holders. But if it's just you and the mortgagor, save a lot of time and money if you include that in all of your loan documents. And again, I will make sure this is emailed out since you guys can't read this very well right now. So, installment land contracts. This is the technical name for a contract for deed. We call them contract for deeds here in Oklahoma. In other parts of the world, you'll hear them called long-term land contracts, land sale contracts, installment loan contracts. So this is essentially combining a deed, a purchase agreement, and a mortgage all in one. Through the contract for deed, you are stating, I will give you a deed at a later date when all of these things have been fulfilled. And normally what you're talking about being fulfilled is you've set a loan amount that they must pay back to you.
Is that a promissory note?
You do not need a promissory note on a contract for deed.
But the set amount, would that be considered a promissory note?
What is the...
Well, in the verbiage, owing a specific amount of money.
It could technically be considered a promissory note, but it's a separate thing. A contract for deed is a contract for deed.
Well, I know what a contract for
Yeah.
deed is, but I'm just curious that.
I've never seen anyone try to have one defined as a promissory note. I'm not really sure what the
Okay.
legal advantage to that would be.
Oh, no, not for us.
Yeah. So this is the statute that frustrates everybody who does contract for deeds. It's Title 16 OS Section 11A. This is the statute on constructive mortgages. So at the very bottom, I've highlighted that. All contracts for deed, a lot of language, shall to that extent be deemed and held mortgages, and so shall be subject to the same rules of foreclosure and to the same regulations, restraints and forms as are prescribed in relation to mortgages. This is why, even if a contract for deed doesn't say the word mortgage anywhere on it, title companies are requiring them to be foreclosed before you can sell that property to a buyer. It's this statute right here.
So let's clarify to people what a contract for deed is
Okay.
and how it works, and is it, some people title them, some people don't, and let's, because this would be a titling issue.
Yeah. So, contract for deed, it's essentially a purchase agreement that includes a financing statement and a promise to deliver a deed at a later date. So I have a house I want to sell to Steve. Steve doesn't have all the money up front, and we don't want to go use a bank for whatever reason. I don't need that much cash. I'd rather get paid over a period of time. So we set up a contract for deed. Steve takes possession of the property. He starts making me monthly payments according to the contract for deed terms, just like you would make your mortgage payments. As he makes those payments, he acquires equity in the property. So it's a $100,000 property. He puts $20,000 down, and we've got an $80,000 contract for deed amount. He's paying me $1,000 a month. As he pays that $1,000 every month, he's acquiring equitable ownership in the property. That is the reasoning behind the constructive mortgage. As the person who still owns the property under a contract for deed, I have legal title. And to the rest of the world, it looks like Steve's my tenant living in that house if we haven't recorded the contract for deed. But in fact, what I've done is given him a full interest in the property. Not like a tenant, you just have to evict. He's got a contractual interest to get ownership of the property if he fulfills all of his requirements under the contract for deed, which is essentially make all of the payments.
Okay, so as an attorney, define the word interest in the property, because I think a lot of judges get confused on, because there's been contract for deeds where people just left and they disappeared, and the landowner continues on with the next contract for deed. But then how do you define interest, and can they walk away from their interest of the property because they're actually paying equitable interest, correct? And then how do you define the amount of money that I'm giving you $1,000 a month? Is there a percentage basis, or is it outlined in the contract for deed?
Should be outlined in the contract for deed. Under a contract for deed, you shouldn't be paying rent.
Okay, so it's
So that should be that entire amount should be principal and interest. Maybe insurance if the owner is paying the insurance and property taxes, just like a mortgage company.
So it's like an owner finance, like a financing contingency.
Yeah, it's exactly like a mortgage, except for you don't take title to the property as the buyer until it's done.
Okay. There was one other question I had and I forgot.
So you, as the person who originally owned the property, maintain legal title. Now, the person who's been making these payments has acquired equity in the property. That equity is a cloud on the title, because under the laws that govern consumer finance, if you have an equitable interest, you can come back and redeem the rest of the property at any point until the sheriff's sale. It's a due process thing.
And you're talking about during the foreclosure process?
Yeah, I mean, up until then. And the equity just doesn't magically go away. They may have stopped paying their contract, they may default under it, but just because they default, just because they move to another state, doesn't mean you can make that equity magically disappear.
Okay, hold on. So let me just say this. So I sold the property on contract for deed. They got divorced. They walked away from the property. They lived in it for 5 years. They have $10,000 worth of equity in that property. They bounce out. I have no written document on the title. There's nothing recorded at the county. They disappear. I sell it to someone else, but they technically have equitable interest of the $10,000 that they paid into it. So two things are going to happen. One, they can come after me for the $10,000 that they paid into it.
On a contract theory for 5 years from the end of date of the contract.
So there's a 5-year window.
Yep, that would fall under the statute of limitations for a contract claim, which would be 5 years from the date the claim arises. That is not a title issue. So title companies probably don't care about that 5-year window.
So that would go
Yep.
on to the landlord. He is responsible to settle out with this individual. If that person, the purchaser could lawyer up, and then you could have a case.
Yeah. I would honestly put into the contract that if you stop making the payments, you default. But you're still going to have to go through the court case to
Prove
that. Now, as you pointed out, this is only an issue if you record the contract for deed.
Okay.
So a lot of people don't record them. You know, no one sees it, no harm, no foul. Title company doesn't see it was there. They don't make a requirement about it.
So is that our tip of the day? Let's be friends here, homie.
It depends. Every contract for deed I've negotiated in the last year has been on behalf of a buyer, and they've all been for over $1 million. I got all of those recorded because I wanted my buyer's interest
You're
recorded.
going to record it,
There's
why
a guy-
not just do the mortgage and note to begin with?
Yeah, there's a guy that's not in here that's just went through that whole it's a friend of mine, a landlord that went through a big legal battle.
I say the same thing,
I mean,
but
if
they
they're gonna
don't.
record it.
They don't want it.
Advantage is to not
They
do
don't
it.
want it.
But see, the
A
person-
contract
the-
for deed
the
is one
landlord is taking
document.
all the advantage.
A mortgage
Taking
and a
all the
promissory
deductions.
notice too. They'd rather me do it for $400 than $600. That's it. That's the answer to your
Well,
question.
the answer is that if you know how to do a mortgage and a note, then.
I would do it every time, mortgage and a note.
Then you gotta foreclose everyone. The reason to do a contract for deed is, like you said,
Well, no, there's a lot of variables here, Pat. Slow down there, buddy. Number one, there might be a mortgage on the existing property already. So you can't give them a true note and mortgage unless you write it in there. That's one problem.
You need a
And then it
support.
could be,
That would be
you can
another
accelerate
issue,
that
yeah.
mortgage if you do that. And if the bank originally finds that, then you're an SOL problem. And then it becomes a collusion.
well, that would be a different set of circumstances, yeah. I'm assuming we were talking about just a free and clear property, that's what he started talking about.
Oh, okay,
Yeah.
I'm sorry.
But he does bring up some other advantages and disadvantages here. If you maintain title under a contract for deed, you have, and one of the reasons this is better maybe for you than a mortgage is that person that you have the contract for deed with isn't going to go borrow against your property. They are not the titled owner. So they might go to a bank and say, hey, I've got this house, loan me money against it. When the bank does their title work, they're going to see that you're the titled owner and they're not. And they're not going to be able
So
to borrow
protection.
against your property.
And more importantly than that is people like Home Depot are not gonna put a big materialman's lien against it for a room that was built on, that you didn't know was built on. As soon as they find out they don't have title to it, they're not gonna do that.
A mechanics and materialman's lien will go ahead of your mortgage.
Well, what I'm saying is during the time they're owning it, normally people like Home Depot, they'll get a financing from them, they'll normally check that before
Okay.
before they
Yeah.
All right, let's
advance
keep on
them.
rolling. Let's keep
Okay.
on rolling. Let's keep on rolling.
So let's move on
We got a
to.
question right here.
I have a
Okay.
question. So you said if you're gonna foreclose on them, they stop paying, why does it go to the sheriff's cell?
Because any foreclosure has to be done by a sheriff's cell. You can't execute on property in the state of Oklahoma unless it's done by the sheriff.
It's called
So
the writ, right?
truly, if your sales price is too low, somebody else could come and bid more and,
Well, you get to bid in the amount of your judgment.
oh, you get to bid in the.
I should have clarified that earlier. So if you have an $85,000 judgment and the bid goes up to 95, you bid in 85 your judgment that the court has awarded you, and then 10 on top of that you would have to come up with if you wanted to maintain the property.
Okay, so let's say you sell somebody a house for purchase price of $100,000,
Okay.
but you give them a 30-year loan.
Okay.
Okay, so you're expecting to get somewhere around $300,000 for the property over 30 years, and 10 years into it, they default. Can you
I will-
ask for any of that?
I will tell you what every bank does in foreclosures. They add up the amount that's still owed on the note. They add up all the unpaid interest, attorney's fees, whatever they paid, lawn mowing fees, all that. And they bid that exact amount at every sheriff's cell. The minute it goes $1 above that, they say, we have 0 expenses left in this now. And they just take the check from the court and walk away. That's what Bank of America, Countrywide, Wells Fargo, all of them do in every foreclosure. And now if you really want a property and you think you can flip it for more, I mean, put the money out there and grab it. But I mean, most institutional lenders are going to bid the amount of their judgment, and if someone wants to bid more than that, they're going to take the cash.
All right, we're changing the subjects here, but are you bona fide on that? Because I've seen deals where they've bidded more than you can kind of.
They could have, but I have never in my career been instructed to bid more than
Because
their judgment.
they're not incentivized.
Well, I mean, let's say you have a judgment for $80,000 and you go to the courthouse and someone says, I will pay that right now to the court. You can continue paying attorney's fees, probably another $2,000, and close out the foreclosure. You can hire a realtor, you can hire a closing company and pay the title.
It's just cleaner, faster.
Or you can just take the check from the court for what
But
someone
that's
bid
what
in.
they're thinking.
That's what the institutional lenders are doing. Like I said, if you think you can make a larger profit,
Buy it.
then buy it. But I mean, that's how it works. I mean,
Okay, cool. All right, any other quick questions? Let's get into list purchases here.
yes.
on this thing with the, again, the same scenario, you bought it for 100, it goes in, say they've been paying rent for so many years, it goes into default. You go to the foreclosure process. Is there a way that you can make an arrangement to get them out of, like, let's say you want to get them off, get their name off of everything, where you go back and resell it again on your own? What do you have to do with that particular one you followed?
Well, that is the foreclosure
You
process.
have to foreclose it. You can't do anything. You can't make a deal on the side with it.
Well, no, if they give you a contract, if they give you a quitclaim deed, any,
If it's titled.
yeah,
Oh, they give you a quick claim. to get out of it.
almost any single title issue in the world other than a probate needing to go through someone's estate can be solved by getting a quitclaim deed from the other
And
party.
then that would let them off the hook for anything, any liability they have as far as on their FICO scores and stuff, because they're not going to show any.
I don't know anything about how FICO scores are calculated.
There wouldn't be a default on their record,
Okay.
though, is what I'm trying to say.
Okay.
You can wipe that out. Okay.
So let's talk about lease purchases, because this is the new thing I get asked about quite often. So, like a contract for deed, if you lease to someone, you are maintaining title in your own name, so they're not going to be able to put liens against it in terms of borrowing. Oh, I'm sorry, this is not the next step. Okay.
Can you see it, buddy?
Okay, so what a lease option is, let's say this building right here. Let's say I owned this building. And what's your name, sir? Let's pick on you for a second.
Ayo.
Ao? Ao wants to buy this building from me, but he doesn't have the money to do it today. But he wants to go ahead and move in and start running his business out of here. So I say, hey, I will lease you this building for 2 years, and you have that 2 years to elect whether or not you want to buy the building for $2 million. You're going to lease it for, whatever it is monthly. So what you have is you have an option. What someone is, okay, let me start over here. So with my agreement with AO, we have an agreement that he will lease it for 2 years. He is going to pay me consideration up front to get that option to buy. So we might work into the contract, depending on how valuable the option is. If this is a building that everybody wants, I might say you're going to need to pay me $20,000 down, $50,000 down to secure this option. And you can credit that against the option price, that's fine. You can put a time limit on that. You can say, I'm going to lease this building for 2 years. You have the option to buy it. But if you're not going to buy it, I need to be able to go and find a new tenant. So you only have the first 18 months of the 24-month lease to exercise the option. That is something you could build into it. Because you want to know, is he going to do that, or do I need to go spend time finding another tenant? Do I need to find another buyer? What do I need to be doing with this? So when you put your option in, you can tell them you have a deadline that you have to exercise it by. Generally, at that same point in that deadline, you say something like, starting at that date, if the option is not exercised, the landlord has the ability to enter the property, to show it to other tenants, to prospective buyers. That's how you protect yourself in a lease option situation. Now, when I have done these in the past, I recommend you come to an agreement on a specific price now. People will argue what a formula means. People will argue what some third-party appraisal means. If you say we're going to look at so-and-so's website 3 years from now, someone might say, well, they're not as good as they were when we signed that contract. We shouldn't rely on them anymore. So my advice is to just figure out what the specific price is. Yes, there's some risk involved. The market might go up in those 2 years, and the property might be worth more. Market might go down, and you might be selling the property at a higher option price than what someone would have paid for it.
How often do you see lease options in your job, your career? Is it a common thing?
It's becoming more common. I'm getting asked about them more and more. I think people have been burned on the foreclosure on the contract for deed a few times, and people are starting to look at lease with purchase options as an alternative to that.
So let me just articulate what you're saying. So a lease option is, hey, I have this property, I want to sell it, we have a potential buyer, but they may not exactly want to fund it, so they're just securing their position or securing that price for that property.
Yeah, they are basically, and you won't be able to sell it to another person during that time. So they are securing the exclusive right to buy the property at a specified later time for a specified price.
Now, I'm assuming if it was me and I was purchasing that property, I would record that, correct? Can you record that?
You can record it if it has a legal description on it. So that's why you want to get the legal description of the property and not just use the street address.
And if you were my attorney,
If I was representing you as the buyer, I would recommend you record
Absolutely.
it. I always recommend the buyer record it, whether it's a contract for deed or whether it's a lease with option to purchase. Because my thought is, if someone else is interested in that property that you have an option to purchase, or that you are the person, the vendee under the contract for deed, then I want everyone else who's interested in that property to know that I have a prior right. I don't want to be in there and find out that my landlord seller is in the middle of negotiating to another party for a higher price, and I might have to suddenly get into a contract dispute with them. So yeah, that is an amazing point, and it's good. Now, if you were the landlord, you might not want that, though. So again, different sides have different priorities here. Yes, sir.
Is there a limit of how long you can have the option open? And then the other question I have is this one contract or two contracts? One for the lease and one for the option to purchase?
You can do it as one or two. If you know at the outset that this is going to be a lease with option to purchase, it's probably easier to do one instrument, have one lease with option language. If you've had a tenant for maybe 2 or 3 years and all you've had is a regular lease with them, and they say, hey, can we talk about me buying this building at some point? Then you can do a separate option-only agreement with them.
So it's basically just an option variant, but instead of a set amount, it's a tenancy involved.
There's no tendency.
Well, as the lessee, you're renting the office building
Right.
before you pay it. Not tenancy like joint tenancy or tenancy in common, but tenant is in landlord and tenant.
Right.
Yeah. Does that make sense?
Yeah.
Let's see what else we got. So the one warning I have about these, because the question I get a lot is people want to turn them into contract for deeds and call them lease with options. They want to basically make it exactly like a contract for deed and just say it's a lease with an option. Well, they'll say, well, your monthly rent payments are all actually going to be applied to the principal.
No.
that's where the interest comes in.
Yeah, so that's if you structure it so that people are making monthly payments against an amount that they owe, no matter what you call it, it's going to be treated by a court as a mortgage and require a foreclosure. Now, if you treat them as a tenant who can buy the property at the end of the term for a lump sum, and maybe you give them a contract for deed or a mortgage
option.
then.
Or a lease option.
Yeah, well, I mean when they exercise the option.
Okay.
Maybe you do sell or carry back financing when they pay the whole thing
That's
off.
after.
Afterwards. But you don't want to operate your lease with option as if it were a contract for deed under a different name.
So this is kind of your way around,
Yeah.
essentially.
Okay, so obviously you can't read the heading on the left, but these last three slides are just sort of ideas of what I've read a lot of potential leases, a lot of lease forms, a lot of contract for deed forms. What I say to every client who asks me to look at their form is, your simple forms are perfectly fine and acceptable as long as nothing goes wrong. I don't think people necessarily need to spend a ton of money and get really long forms if all their deals are working out, if you vet your people well. But if you want to have better forms, these are some of the things that I don't always see in the forms that people bring to me that I think should be included in. When you're talking about whether it's a contract for deed or a lease with option, you're contemplating delivering a deed to someone at a future date. Your lease option or your contract for deed should explain what that deed is. Are you giving them a quitclaim deed? Are you giving them a warranty deed? Are they entitled to take this to a title company and have them read it for title insurance before you close?
Great point.
Do you want to try and send it to your title insurance escrow closer that you like by putting their name into the contract right now? So things like that can factor into it. And now, also with a lease option, sadly, I represented the buyer in this, and he was the party who couldn't get his shit together. But how long are you going to give them to get financing? I had a buyer that it took him 2 months before the sellers finally just dropped him because he kept saying he was going to get the money, and he didn't. So if you're doing your lease option, you might want to say, the purchase will happen on this date, this agreement will be void if financing by the buyer cannot be obtained within a month of that date or something. You don't want to potentially be on the hook for them going around to various banks trying to find someone who will loan them money. So again, that kind of goes with the last point there too. At what point do you want to be able to break your lease option? How long are you going to put up with them if you don't think they're going to fulfill this? So consider things like that when you're drafting. Other sort of general clauses. I'm a big fan of mediation. It's cheaper than me. It's cheaper than all lawyers, essentially. If you need to mediate an issue in a contract, I know an attorney who will do it for $400 for a half day and like $900 for a full day, I think, or $500 and $900. And that is opposed to paying maybe $4,000 to $5,000 for a prolonged court fight. So I'm a big fan of saying that your first remedy is to take it to a mediator. I think it potentially saves people money, even if it takes business away from me. Responsibility for taxes and insurance. Depending on the kind of deal you're doing, different people will want either the seller or the buyer to be responsible for these, and you can make it however you want. Typically, under a mortgage where the property is titled and the buyer is going to be responsible for taxes and insurance. In a leasing situation where you still own the building, you probably want to be responsible for the taxes and insurance to make sure that it's all handled well. If you're not, you probably want to say something in there that you need to be named as an additional insured on any policies they get covering the land that you own.
And benefit rights.
And benefit rights. Assignment of proceeds. And that's kind of what we're getting. Skipping over subletting for a second. Disaster, insurance payouts, condemnations. If this land gets, the OTA just, when I was at First American, I think we did 300 title opinions on land the OTA condemned for Oklahoma Turnpike Authority for the turnpike expansions that are going on. So, maybe you have no land anywhere near a highway and you're not worried about that, but if you're in the middle of a lease option agreement and OTA or somebody else comes by and says, hey, we're expanding to Kilpatrick, we need that now, you're going to get paid and you're going to get compensated for it. But if someone else has already paid the option to purchase that property from you, and now, that's what you can put in. Some people would rather just have the money. So you might say, okay, let's fill out the terms and you get whatever the OTA pays us. Or you might want to let them get out of it and just collect that money yourself. So a lot of more complicated contracts will contemplate that things like that, or tornadoes here could happen. Subletting and assignability, this is all just a matter of personal preference, in my opinion. Do you want your tenants, the people on your contracts for deeds, to be able to lease to someone else, to assign your instrument? That's up to you. Just if you don't think you want those things, I would put prohibitions against them in your instruments. Unless you're just really wanting someone to make monthly payments for a long time, I usually suggest putting in no prepayment penalty. If someone's got your lump sum payment ready to go and it's early, I would take it. That's also a matter of preference. Due and payable clauses on breach and default. Anytime you're doing a financing instrument, you should state in there at some point that whenever the contract is breached, it's due in full at that point. If you don't, then theoretically you're only entitled to the amount of payments they've missed.
Would that be considered like the same thing in a mortgage as an accelerator?
Yeah, it's the same thing as an acceleration clause in a mortgage.
Just cut and paste.
Yep, exactly. Okay, so that top part says merger and integration clauses. How many of you guys have verbal discussions with your potential buyers before you sign a contract? Yeah, exactly. So it's sort of a rhetorical question. So what a merger or an integration clause is, it says all previous oral communications, written or verbal agreements between the parties are superseded and incorporated into this written agreement.
So like a text message that agreed upon something before, prior?
Yep. So basically what that is saying is if it doesn't get into the actual written contract, then it means we didn't agree to it, even if we talked about it before.
That's probably not the best clause to have it.
I understand that. You guys have different types of business models. Everybody does things differently. But that if you are worried about people who always come back to you and say stuff like, well, didn't you say this? Didn't you say that? Maybe that's an option. Maybe it's not. Indemnities, this might already be in your agreements under different wording. But this is the idea that if you have a tenant on one of your properties and they have a friend who comes over, gets drunk, and hurts themselves, they're indemnifying you for any liability that person might have because there was a hole on the property or you're missing a step or something. You can do the same thing with the liens. Now, they're not going to be able to borrow money against your property if they're a tenant, but if they're not taking care of the yard, if they're letting structures fall apart, you might get a mowing lien filed against you. If part of your lease is that it's their responsibility to take care of the yard, you can put in there that they indemnify you if any liens are filed.
Actually, that has happened to me, and it turns into a criminal case when against the city.
It does?
Jackie, remember that? What was that? What's that called when I got sued on that? It turned into a criminal case. Because why did they turn into a criminal case?
If you don't show up, they'll issue a warrant for your arrest.
Oh.
So basically what happened was the tenant did not cut the grass. I'm still on title. Then it escalated because I never got the notices. And then next thing you know, it turned into a criminal case. And we had to go before the judge and explain the situation. So how do you fix that situation? So that doesn't happen again.
This is not a legal answer.
Oh, okay. Way to go, Jordy.
Pragmatically, I just go over there and mow it.
Whack, get out of here.
But
I didn't know it happened.
I honestly didn't know
like
that.
3 months later, I'm getting sued. I have a bitch warrant.
I have
over a grass.
I have gotten those liens released before, but I've never actually been involved with that.
I'm serious. Let's answer this question, Jackie. Let's help this guy. What happened? Like the house that I sold that guy.
It sounds like the criminal element was because they didn't show up in court, though. That's not a real estate issue.
But a lot of people don't know that when there's a city fine is an actual criminal act. A city fine turns into a criminal act, which
name is on title at the county assessor's office.
It's not a flippant little fine. It's a criminal act that you can go on your record.
I thought you said that they got a bench warrant for not showing up at the hearing.
If you don't show up, you try to ignore them, they will
It's just not like a little fine.
But the fine wasn't for not mowing the grass, it was for not showing up at the hearing. Not the fine, I mean the bench warrant.
For probably not showing up, correct. Okay. But if you don't get this notice.
The trash and debris is like $250 fine.
But this is like a real case that happened.
Yeah, I understand that.
So the property owner is responsible for the fines on the property that he owns. So the city files against him, but if the mailing address is wrong and he doesn't get the notice, and then it goes to court, they issue a bench warrant because it's in contempt of court, doesn't show up to court. Hopefully at some point, they send him that bench warrant as some kind of a notice. Then you have to solve.
Well, what happened was it came into a big issue where we're like, "Hey, man, we don't own this property," because it was like a owner. I can't remember owner finance contract or deed, similar creative situation. But then I'm on title, so I was 100% responsible. But we did through some petitions because it was all the way at we're about to go to jail point, and Jackie represented me, and the judge understood what was going on. Like, hey, we've done all our due diligence. We've let this tenant buyer know this is their responsibility. Here's all the financial documents. Dude, you own the crib. It's just not in my name, and you're not in your name right now. You are 100% responsible. You knew about this. We've sent you certified mail. You need to, because it got extreme. The dude wouldn't pay it. And so, you're in a pickle if he doesn't want to pay, because he still has ownership of the home because he has interest in the home. So I can't just go pay for the liens. So anyway, it worked out though, but we had to stand before the judge and prove our case that it wasn't technically my responsibility, but it kind of is. But the judge saw it in a different light.
How did it work out?
I'm not in jail.
We filed the contract.
It worked out. But what I did was I was so amped up on this dude. I was like, the next day I titled it in his name, because I kept the title in my name because I had a loan on the property. You understand? So I had a lien. I had a loan on the property, and I contracted deeded to him. Does everybody follow me on that situation? And so now
he's going to show up on the county assessor record.
Yeah, now that joker. And so what happened was, this was going on for a long time. We had to go back and retro all of what happened to show the judge. I'm just letting you know,
So
it gets a little
why didn't
sticky.
you get notice?
No, we got notices, and we kept sending it on to the guy, and he kept saying that he was going to pay.
I just would have paid it and ended the problem.
Okay. How many houses do you have?
Couldn't you do it in a situation like that? Can you write that in?
Yes, sir.
Can't you just make the payment and attach it to his next payment? like rent, I mean.
If you put that in your, well, if you put
If you have that in a document.
if you have that in the document, you still have to be able to recover it from him.
Did you not have a due and payable clause where if he's in breach of contract and doesn't pay for the mowing,
Then I have
you
to
kick him
foreclose
out?
on the guy.
Don't you, just put
That's
it,
just
I put in
leverage.
all my stuff, leases or contract for deeds, and I've done a lot of them, that any illegal act voids your agreement.
Yeah, but keep in mind, this was a $5,000 house I bought.
You didn't want it back, so did
I didn't want it back.
It's
Let's just be
leverage.
clear.
It's leverage against him.
Leverage against
No,
trash.
He wants to keep it. He loses his money. You have the
Anyway,
leverage.
we can. If you want to talk about this later, we can. This superstar up here, he's got more. He's dropping knowledge on us here.
So other things that you might want to include in there, you want, this is sort of the opposite of Steve's problem, but you want clauses in there that if they abandon the property, if they walk away from it, you're entitled to take possession.
Okay, let's talk about that one. You post a notice. What's the time frame?
That is not what I'm getting at. I don't do FEDs.
No, you have that. I have abandonment notice in mine. Okay, what's my legal action when they disappear, they don't pay, and you can't get a hold of them? What's the legal way to handle that deal? Because they have interest in it now.
Well, the legal way is to foreclose them out if they have an equitable interest and it's been recorded. If it hasn't been recorded, you cross your fingers and hope you don't get in trouble for lying on the title company affidavit.
Okay. Basically,
Back to indemnity. So can you explain to me what that means? Are you saying that anything that you, my tenant / buyer, does, I won't be held responsible for? Is that
Yeah,
what it
so
means?
let's, if I rent a house to my neighbor, it's technically my house and I am the licensor, and if there's something wrong with the property and someone hurts themselves, they would sue me. The idea of an indemnity, and if you have property and premises insurance, you're hopefully covered. But the idea of the indemnity is that if the person gets injured on your property because of something your tenant, your buyer, whatever does, then that person is responsible to indemnify you, which means take care of in your place any damages that would be attributable to you as owner. Now, that is something you might have to force them to do through court, but it is a way to protect yourself. One other thing I've noted, this depends on where your property is. Things in the CC&Rs, the plat, and the HOA documents might supersede what's in your agreement. You might have in your agreement that you can have 6 dogs. If the CC&Rs say that all the houses in that neighborhood are limited to 4, the CC&Rs are going to control over your agreement. So this isn't necessarily a legal term, but when I work with people on these, I like to point that out as a note, that this agreement is subject to any further restrictions in the recorded CC&Rs or bylaws. That way they can't come back on my guy and say, well, you lied to me about that. You told me I could do this, but now the homeowners association is saying I can't. Just say that you put in there something that's your responsibility, that you're not vouching for what the HOA says you can or cannot do. And this was the final slide. You can't really see it. This was a chart of the 3 different options, where the legal title is, whether a foreclosure is required, and what needs to be recorded. So I will send this presentation as a PDF to Steve and Jackie, and they can circulate it to the group. I apologize you weren't able to see it very well, sir.
So y'all keep on saying that the tenants have rights to the property. That's the reason why I asked the question. Is it better to have 2 different contracts?
The tenant, I'm using the word tenant to describe them in 2 situations, essentially. If you're doing a lease with option to purchase, their only right is in the option to purchase.
Correct.
If you're doing a contract for deed, the person who lives on the property has greater rights in the property. More so if it's recorded, but they're requiring equity. So, does that answer your question, or can I be more specific? Can you?
So I guess, in my mind, if I'm doing the 2 different contracts, I have a lease, they're just leasing it.
Mhm.
At the end of the time period, if it's 2 years, then they have the option to purchase.
That is a perfectly acceptable way to do it. If
That
that's
way
how.
they have no legal rights to the property as far
I mean,
as...
there's the Landlord Tenant Act, which I'm not super familiar with. I don't do landlord tenant disputes, but they might have something under that. I'm not familiar. But in terms of title, In terms of equity, no. If they haven't executed an option yet, if they're just a tenant under a lease, they have no title interest or equitable interest.
Landlord-tenant act wouldn't give them any ownership interest.
Yeah. Maybe it gives them some sort of right about possession or when they can be kicked out, but not a title or an equitable interest. Any other questions? Yes, ma'am.
I have a question. If you do record the title into their name and let's say they either don't pay their federal taxes or state taxes, or there's a seizure of some sort regarding like with the federal government, I know your mortgage becomes secondary to obviously the IRS lien. I don't know about a federal seizure, but like, do you have any recourse? Who else would become primary? I mean, aside from those two entities, do you have any worry on
the
that?
way the IRS files liens is against the person's name, usually not against a legal description. Now, seizure is a different case, and I've really only seen one big seizure, and I'm not confident enough to extrapolate from that. But on just regular IRS tax liens, they file them against a person's name, and so they file them in the county records. That attaches to any property that the person owns. So if it's truly a tenant, and John Smith is just a tenant, and you said they were titled, though, right?
They're titled.
Okay, so if they are titled, and an IRS lien is filed against their name, then that will attach to the property. So that is one reason why if you're doing a lease, you're a little more protected. But then again, they haven't committed to purchase, so you might not have the financial reward you'd get under a contract for deed or a full-out mortgage. So again, a lot of this is not so much that there's a definite right or wrong. It's what's your risk tolerance, what is your business model, and what are you willing to put up with, and how much do you want to put into your agreements. Yes.
So on a, let's see, lease for deed, land for deed. So Stephen was saying you could put in there, if they abandon or stop paying, that you get the property back. If you haven't registered the mortgage, it's just any title company.
So,
Does that work?
well, if you can put stuff in there, that they will return. I've written in a contract for deed before that if the party defaults, they're required to sign a deed over to the seller. If they default, you're not going to be able to find them, and you're not going to be able to enforce that probably. If no one knows about your contract for deed, then you probably don't need to do anything. If it's filed of record, you're going to have to foreclose them out. I can't say for 100% sure, but you will be asked, if your buyer chooses to close at a title company as a seller, you will be asked to sign a seller's affidavit that will ask if you know about any other potential claims on the property. If the contract for deed has been, no one's paid on it for years, maybe it's not a claim. If the person walked out a month ago, I don't know if I'd feel comfortable saying that there's nothing else on the property.
So strategy idea on that. If you still have a way to contact the person that defaulted on the contract for deed, offer them a small amount of money for them to sign over a quick claim deed back to you.
I had someone
They
do that.
win,
Yeah.
you win.
I had someone do that the other day. They paid a seller $500 to get a deed from them, a curative deed. Someone had lost their property and they still needed to get.
What's the general cost in money and time for a foreclosure?
Foreclosure is going to be more expensive than a quiet title or a probate. So foreclosures, I generally tell people about $4,000 to $5,000 if it's unopposed, because you're going to be going to the court a lot more often. You have to do a lot more notice requirements and mail out a bunch of stuff. Quiet title pleadings, it's like 6 or 7 total. Probate, if you're doing a simple probate, maybe it's 6 or 7 pleadings, like documents. A probate is maybe 11 or 12 documents you file. A foreclosure is more like 25 to 30. So, just to give you an example of why it costs.
And what's a quiet title over a foreclosure? What is that?
Quiet title would be if you bought property at tax sale and you needed to fix some curative issues.
Hey, Ryan. You mentioned earlier, I never heard this before, called the power of a sale. And is that a power of a sale foreclosure?
Yes.
Is that a clause, or is that like a process that you can?
It's a particular part of the mortgage code.
Okay.
And what it lets you do, it means your foreclosure procedures are governed by a different set of statutes than a regular foreclosure. So what you have to do according to the statute is include this phrase which comes from 46 OS section 43, and it must be bold and underlined on your mortgage. I have never seen someone use this on a contract for deed, but I am including it on the contract for deeds I draft under the theory that I think I can get it to work if I have to foreclose a contract for deed. I have not seen anyone try yet, but I'm going to at some point. I think it might work. So you put this on there, and your steps are a lot shorter. You have to essentially send certified letters to the people you're foreclosing. Anybody else who has a lien on the property, you have to publish notice. But then it's just sort of a waiting period for them to respond, and if they don't respond, you get to move forward with the foreclosure. So it's a lot quicker. But again, there are some, I don't have all these memorized. I don't do a ton of foreclosures. But there are some exceptions to when you can do it.
So why don't you explain like a deed in lieu to folks?
A deed in lieu would be if, technically they apply to mortgages, but I suppose you could do them in any financing context. So someone has granted you a mortgage on property and they can't pay it back. And instead of just disappearing or running off, they're still around and they want to get rid of this debt. So they give you a deed in lieu of a foreclosure. And by doing that, they are conveying to you, the lender, all of their interest in the property, essentially giving you back both legal and equitable title without you having to do a foreclosure.
And now you're in control.
Now you're in control. If there are no other liens against the property, that is a perfect solution. The only issue is if you have your senior tax liens, you have mechanics and materialmen's liens or something like that. Those don't get taken care of in a deed in lieu context because there's no court process.
So
and
they're
notice.
attached to.
So they're attached. So it may not work if there are other liens, but if the only lien out there is the one between you and the other person, and they're willing to sign the deed in lieu, I think that's a great solution.
What do you guys think of this rock star Ryan? What do you think? Hold on, before you get started, what's your phone number? Do you have any business cards? I creeped you up on Facebook. I know you're like a real estate attorney.
Yeah.
So, you know, how long you been practicing law?
So I started practicing in 2011. I practiced in Enid for 2.5 years doing general civil litigation and title work for banks. From 2013 till last November, I was with First American doing residential title. I joined Munson & McMillan on December 1st. They are an oil and gas firm in Edmond, and they hired me to start a real estate and surface title practice for them. So I'm up there. We do stuff all over the state. We represent oil and gas clients and title curative mineral actions everywhere, all around the state. So we're happy to go and do stuff on property you might have that's outside of the metro. This is all I do essentially, not foreclosures, but surface real estate, surface title. I do a lot of surface title examinations for rural abstractors who don't have in-house attorneys. I also do a lot of document drafting, do commercial real estate document drafting as well. We'll go back to my contact if you didn't get one of my cards. I am always happy, rschaller at munsonmcmillan.com. I've got a business Facebook page too. I will answer you can email me anything, just, this is my issue, what would it take to fix, and what is your estimate? I am always happy to tell you whether I think you need an attorney and what I would charge. I'll tell you that for free anytime. I'm happy to, so feel free to just call me and ask or send me an email. I'm happy to talk to anyone. Yes.
One question about that power of sale option for a mortgage. If you were to put that in a contract for deed, how would you change that verbiage?
I hadn't really thought about it. I would probably just change.
An addendum?
I would probably just change the word mortgage to installment land contract everywhere it says. Or this power of sale has been granted in this contract for deed. A power of sale may allow technically you're the vendor if you grant a contract for deed to someone. I would maybe just say the holder of the contract for deed to take the secured property is another word for mortgage that doesn't mean just mortgaged, and sell it without going to court in a foreclosure action. You know what? I would just keep it the same. Because the statute says that it wants that language on there.
Treated like a mortgage.
So I would just use the language from the statute, and if someone says this is a contract for deed, say, well, the statute says to use this language, so I use this language. Now that I think about it, I think that's what I would do. I wouldn't tinker with it. Any other questions?
Any burning questions? Nobody has any questions for free? How much do you charge now?
$225, $200 for pure title work. Yes, sir.
I don't know what this is, but the way it was described to me to do something like this was to set up collecting payments from the person who wanted the property I'm trying to do. And he said you would take payments for 5 years. At the end of 5 years, there'd be a balloon payment. And it gives them 5 years to get a mortgage through somebody else or give the property back to you.
Are those payments they're making in the first 5 years against the total amount? And then the balloon, so like, are they paying against
Yes.
okay. To me, that sounds like a short-term mortgage with the balloon payment. I mean, you can maybe call that, what, sir?
It's gonna be treated the same.
Yeah, I mean, that sounds like a 5-year mortgage with a balloon payment at the end. I don't think it's anything.
Well, the reason this particular guy liked it was that they either got their act together and they.
Oh.
And they had, he was not responsible for the property. He was just like, leave him alone for 5 years when they're making the payments, and after 5 years, either they bought it or he got it back.
Yeah, and again, like I said earlier, a lot of these things are how you want to run your own business and what you prefer to do.
He'd even go up and give them, a few $100s for their keys and move them out, fix it up, and start over again.
I think that sounds like a decent plan.
Hey, can you turn that light on back there? Somebody turn that light on so we can see. Thank you.
What was that, Jackie?
Dodd-Frank might have something to say about balloon payments.
I've been asked that question before about Dodd-Frank and seller financing, and I haven't taken the time to completely research it. I believe, was it the 4 mortgage rule now, or is it the 3? I think you are, and again, I have not researched Dodd-Frank, but my very elementary understanding is that if you loan out more than 4 mortgages in a year, you're at risk of being classified as a loan originator under the federal government, which would put additional liabilities upon you.
And that's originating for a year or just carrying for a year?
The language is not clear. My interpretation is originating for a year. I'm like 85% confident with my interpretation. I'm more than halfway, but I'm not 100%.
I have your card. I can send you to him. I'll send them to you.
No, I do seller financing mortgages and financing instruments. When I was at First American, I got a big first-hand look at how all the CFPB and the residential and all of that, and that's just a big mess that I don't want to get involved with. I don't need to. So there's just so many more rules and regulations when you start dealing with the home loans that are covered under that, and you make enough. Yeah.
Do you have advice on subject to and transactions? Because we're talking.
I mean, I would make sure you're fully apprised of the situation on the property, and you know what you're getting yourself into. Just because you think you're taking it subject to one loan, you want to make sure you do your homework and that there isn't anything else bothering you on the property. Just make sure it's clear on what's going to happen. I had that. Again, it's one of those things that usually works out well until it doesn't. I had a lady call me from northeast of Tulsa. I don't know the details on this because I had no desire to drive 2 hours for a case. But she had bought a house on what she thought was a lease option, was really structured like a contract for deed. The person she bought it from had a contract of deed with another seller. The first guy got foreclosed on. She never knew that the person she had to deal with didn't have good title. So, I mean, I think for me, it's just you make sure you understand what the picture is, and you make sure your instruments clearly state who's responsible for what.
All right, put your hands together for my man, Ryan.
What is the Savvy Boot Camp? Are you struggling to get to the next level as a business owner? As an investor? Do you want to multiply your income? Sign up for the Savvy Boot Camp, a strategic and supercharged one-night and one-day event designed to shortcut your learning process and propel you forward. Just value, no upsells, and an intimate setting to build relationships with like-minded investors.
We will be covering how personality profiling can make you a millionaire, outsourcing and the nitty-gritty of maximizing your property management, scaling your business through systems and automation, technology hacks you should be using every day, and how to raise private money. Go to www.savvybootcamp.com now to register or to find out more.
Thanks for listening to the Savvy Radio Show. Glide online and listen to our other motivating episodes at savvyradioshow.com. Connect on Twitter at LandlordBook and always be buying assets.